Hello, I'm attorney Morris E. Fisher, and I welcome you to our YouTube channel. And I welcome you to watch the other YouTube videos and podcasts and to subscribe, and also to visit my website, www.morrisfisherlaw.com. Today's video, the latest updates on the Trump terminations. And as everyone knows, President Trump and OPM issued executive orders and memoranda in connection with plans to reduce and reorganize the federal workforce. And federal agencies were directed to provide OPM with a list of all probationary employees. And then agencies were directed to, quote, promptly determine which probationary employees should be retained. And there was another executive order which called on these agencies to initiate large-scale reductions in force and develop reorganization plans. And what most people anticipated was that Elon Musk and his team would help these agencies out, would go through each agency's branch by branch, department by department, component by component. They'd look for the fraud, the waste, the abuse. They'd discover what positions were no longer needed and eliminate those positions. And this wouldn't be a perfect system. There would be some employees with a combination of essential and non-essential duties. And Musk and his team would reorganize those kinds of employees, eliminate some of them, keep some of them, and have the ones that they kept maintain their jobs performing only essential tasks. And I suppose that when one hires the richest man in the world and the smartest business guy out there, that's what we would expect. And most taxpayers would be feeling pretty good about that and expect some sort of tax reduction, or at the very least, have the deficit come down substantially. But that's not what Elon Musk and his team have done. Instead, they just came up with a plan to eliminate certain classes of employees en masse. And the best example of that is this: all probationary employees at any given agency have to be eliminated, notwithstanding the talent or productivity level of any individual employee. I mean, think about it. You might have a probationary employee who's an all-star, someone being paid as a GS-11, may be doing some of the work of a GS-14. And then you have a GS-14 who's not probationary doing very little. So under these circumstances, probationary employees may have legal recourse. And the key argument for probationary employees being eliminated is that any particular termination is really the result of a reduction in force or a RIF. So people will say, well, so what? Well, reductions in force of federal agencies are governed by certain statutes in the United States Code and certain regulations, such as 5 USC 3502 or 5 CFR 351. Or 5 CFR 315-801, there are many. And these statutes and regulations, they concern the following merit principles. Selection and advancement should be determined solely on the basis of ability, knowledge, and skills. All employees should be receiving fair and equitable treatment with proper regard for constitutional rights. The federal workforce should be used efficiently and effectively. Employees should be retained on the basis of the adequacy of their performance, and employees should be protected against arbitrary action. The regulations define a reorganization as, quote, the planned elimination, addition, or redistribution of functions or duties in the organization. That's 5 CFR 351.203. And the Federal Circuit has defined a reduction in force as an administrative procedure by which agencies can eliminate jobs and reassign or separate duties or separate employees who occupied the abolished positions. Now, keep in mind, it does not say None of these regulations say the following. A RIF is an elimination of people en masse in order to get voter empathy in the Midwest or wherever it is. That's not what the regulations do. The regulations there's a specific format that must be followed. There are procedures, and we'll get into the reasons for this. And if you think about it, what is the reason for this? And I got one in one of my earlier videos. I got a comment from someone who said something to the effect of, well, wait a second. OPM and these regulations, they fall under the president anyway. So why can't OPM just change the regulations? Doesn't OPM just report to the president? Can't the president just do whatever he feels like doing and running the executive branch of the government? And the answer is no, he can't. And again, these agencies were created by Congress. And OPM and these kinds of federal regulations are there to make sure the agencies run fairly and efficiently. So, for example, OPM can't come up with a new regulation that says something like, well, agencies can do what they want. Here's an example. FEMA can decide not to respond to hurricanes in South Carolina. And if they want to fire all personnel assigned to hurricanes in South Carolina, well, FEMA can do that. The president can do that. No, they can't. FEMA is created by Congress, partly to address natural disasters in South Carolina, as well as all the other 49 states. Congress is made up of the House of Representatives and the Senate. As everyone knows, they pass laws that reflect the will of the people. And in my example, the will of the people was to create the federal agency that addresses natural disasters all over the United States, even in South Carolina. And the president and the executive branch of government cannot interfere with that mission. They can't rewrite these OPM regulations to accommodate that desire. And that's very important because if you're a probationary employee and you got one of these notices, particularly if you got a notice that said something like, you were a lousy employee, you weren't meeting the conditions of employment, you weren't showing that you were a satisfactory employee. We have cases now involving that, where there was nothing but excellent review structure. The employee got his PMAPs, they were good. He got his PWPs, they were good. Everything, he's got supervisors saying this guy was an all-star, he's an excellent employee. So for someone to get such a letter that could affect his or her career, I mean, think about it. Someone has to now report that termination, certainly if they're applying again at some later point for a federal job, that's going to hurt. And that shouldn't be in somebody's record. So if you have been terminated recently by the federal government, or you got one of those notices, whether you're probationary, you're not probationary, call us. We can help. It's what we do. Call to book your initial 1.5 hour consultation today.